Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 228 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. Today I take a visit north of the border with John Boscariol. John is a partner at McCarthy Tetra in Montreal, and he is an export control expert. Obviously in Canadian law, but a lot of experience in U.S. law as well. John takes a look at some of the significant developments in Canadian export control law in 2015. Then he helps us take a look at what may be some of the things that will come up in 2016 and go forward. He spends a fair amount of time talking about the lifting of the Iranian sanctions, what that will be for U.S. Companies who do business in Canada and then sell. And he also talks about Cuba. You'll find it very interesting. The episode comes in at just under 30 minutes. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today you are in for a real treat because I have John Boscariol from the law firm of McCarthy Tetra in Montreal. John, welcome.
Thanks very much, Tom. It's a pleasure to be speaking with you and your listeners today.
John is a well-known Canadian lawyer, particularly in the field of export control. He is one of the most prolific writers I know, and coming from me, that's saying a whole lot. But he recently wrote a piece which caught my eye, which was entitled Key Developments in Export Control and Economic Sanctions During 2015 and What to Expect in 2016. So I asked John if he might be able to take some time from his schedule to come on the podcast and talk to us about export control, obviously from a Canadian perspective, but a lot of sort of commingled developments that may be important for both U.S. Canadian companies going forward into 2016. So with that, John, what did you see or what piqued your interest or what did you think was important from the export control perspective in Canada in 2015?
Well, thanks very much, Tom. Yeah, there are a few developments in 2015, and just to give you a bit of lay of the land here in Canada, as many of your listeners may know, Canada doesn't have the same type of, maybe lack for a better expression, but name and shame system or practice that you might see in the U.S. when it comes to economic sanctions and export controls. Here in Canada, there is enforcement. We don't see the multi-million-dollar penalties, at least not yet, that we've seen in the United States. But there's a lot of enforcement at the border. There's a lot of things going on behind the scenes for Canadian companies that are trying to do business and export controlled goods or with sanctioned countries, and sometimes find themselves falling a bit behind and keeping up with some of these rules. All of that being said, there were, I think, some pretty interesting developments here in Canada during 2015, and a lot of them are already highlighted in the legal alert that we had sent around on January the 15th, but I wanted to mention a couple of them. One which really caught our eye beginning of the year in January was a settlement. And this time it wasn't an announcement of a penalty against an exporter who had violated the law, but in fact a settlement against the Canadian government for wrongfully prosecuting a Canadian company, actually two Canadian business people, a father and daughter, who had been criminally charged for failure to obtain export permits for shipping what was thought to be 5,100 dual-use chips and circuit boards to Hong Kong. Again, they didn't apply for a permit. On further investigation, after the charges had been laid and the prosecution proceeded, it was determined that there was no basis for the charge, and the charges were withdrawn. Everyone agreed that the items actually were not export controlled. But as a result of the charges, and I think there's a bigger story here about the reputational impact of export controls. In this case, as a result of the charges, the business of these two accused persons were destroyed. No one wanted to do business with them. They felt they were a high risk, and as a result, the court found that they should be awarded over $10 million in damages, the second highest kind of award for wrongful prosecution in Canada. And the government, as far as I understand, has not appealed that decision. So it was just something, again, that caught our eye, not so much as a penalty, absolutely not a penalty against the exporter, but an important indication of the consequences, the reputational consequences of export control violations, and in this case, the consequences when they weren't even true. The other area, Tom, I wanted to talk a bit about was our sanctions against Russia and Ukraine. A number of the allied countries have these sanctions in place and have now since, I think it was first in 2014 when we put them into place. But Canada has become particularly aggressive in the breadth of these sanctions measures, and in some cases, we're finding at least that these measures are broader than the U.S. counterparts or the EU counterparts when it comes to sanctions against Russia. During 2014, Canada continued to add blacklisted entities and individuals to its sanction program for Russia and Ukraine. I believe now Canada has the highest number of blacklisted parties out of all the allied countries. And Canada also went ahead and imposed a very broad trade embargo against the region of Crimea in the Ukraine. And I know that's at least that measure is quite similar to what the U.S. has in place, but that is also providing a lot of challenges for Canadian companies that are doing business anywhere in that area or with Ukraine, because they have to figure out now whether their business partner or an end user is located in the Crimea region of Ukraine. Something you don't see identified on addresses or on websites or anything like that. So that has introduced a new challenge for Canadian companies, and I think they're continuing to struggle with that, as well as just the large number of blacklisted persons under these sanctions measures. On the export control side, Canada issued a new dual-use general permit. This is similar to in the United States when the Department of Commerce has a general license, where if you have something that is controlled but it meets the conditions of the general permit, you are able to go ahead and export it without having to apply for an individual permit every time you engage in the export. So we're quite excited about that. It applies to most dual-use goods and technology that are on Group 1 of our export control list, which lines up fairly generally, I think, with the U.S. Commerce Control List, and certainly covers all of the Wassenaar dual-use items. We call this GEP, General Export Permit number 41. Basically allows most of those items to be exported to a list of friendly countries that have similar export control regimes. So that, I think, represents significant liberalization or more flexibility for Canadian exporters of goods and technology, at least when they're dealing with those 20 or so countries that are eligible for that general export permit number 41.
John, if I could stop you there. Of
Sure.
course, I'm in Houston, so we have a fair amount of Houston-based energy companies with either subsidiaries or very close customer relationships in Canada. And often U.S. companies will ship to their either Canadian subsidiaries or to customers in Canada, who then ship out to other countries across the globe. any thoughts on how this new dual-use export permit would work with the U.S. export part of that permit, or does it really, it's two separate regimes that a company has to comply with once the goods get into Canada?
Yeah, there's an interesting interaction between the U.S. and Canadian export control systems here. So when we're dealing with destinations where there is a broad U.S. trade embargo in place, so namely Iran, Syria, Cuba, and it used to be Burma, but Burma's no longer on that list. But with countries like those, if you have a U.S. origin item in Canada, so if that Canadian company you mentioned has a U.S. origin item, that Canadian company doesn't have to be U.S. owned for this to apply. But if they've got U.S. origin good or technology that they're going to transfer to one of those countries like Iran, Syria, or Cuba, under Canadian law, they must get an export permit for that transfer. And so they must go to our Export Controls Division, part of our Global Affairs Canada department here in the federal government, and get a permit. And usually in order to get that permit, you're going to need to either show that you got a license from the U.S., from the Department of Commerce, or in some cases OFAC, or to show that that export would qualify under an existing kind of exemption under U.S. law, or thirdly, if it's for humanitarian purposes. So there is some respect, if you will, that's given to the U.S. export control regime under Canadian law. There's some recognition that Canada doesn't want to be seen as a means of avoiding the application of U.S. export control laws. So our systems in some places there work together. Now, with the scenario you mentioned, Tom, when they send up something up to Canada and it's controlled, you would be able to take advantage of GEP 41, assuming it's one of the 20 or so countries that I mentioned earlier that are the destination for that item. So that would not include some of those axis of evil destinations like Iran or North Korea. But if it's going to the UK, most European countries, Australia, Japan, you could take advantage of GEP 41. It doesn't matter that that item is U.S. origin or not. You're still able to take advantage of that GEP.
Okay. What else did you see from 2015 that sort of piqued your interest or you thought was important to talk to clients about?
The other item was an interesting announcement that came later in the year, actually in November. Our Customs Authority, the Canada Border Services Agency, most known for being aggressive on the import side, is also closely monitoring exports. And in fact, when you export an item from Canada, you have to file an export report with CBSA, probably similar to something you do with Customs and Border Protection in the United States. But here in Canada in November, CBSA issued a notice to put exporters on essentially to warn them that they were aware of a number of instances where Canadian exporters were shipping goods to the United States and then having those goods move through the United States to a third destination, in most cases Mexico, but not all cases, and using an exemption from export reporting that was available when you export goods to the United States. So again, we have a close relationship with the United States, and when it comes to export reporting, there's a general rule in Canada that if you're shipping goods to the United States, you don't have to report them. However, CBSA has learned that, particularly in the auto industry, but other industries as well, there's been a number of exporters who have been shipping goods saying they're going into the United States, but the goods are only moving through the United States and going into countries like Mexico and not being properly reported to CBSA. So in November, a customs notice was issued, basically warning exporters that CBSA will be auditing them starting in June of 2016. So we expect to see a number of these audits initiated. CBSA put out the notice to say, if you haven't reported in the past, come forward, and this applies 6 years back, come forward and do a voluntary disclosure and you won't be penalized. So we have a lot of companies up here now looking at what their practices are for reporting their exports to the United States. And of course, 80% of our exports go to the United States, so this is a big issue for Canadian companies. The other thing, Tom, we saw later in the year was a report that our RCMP, who are Royal Canadian Mounted Police, who are responsible for enforcing our export control laws, had laid charges against 2 Quebec businessmen for the export of U.S. manufactured rail equipment from Canada to Iran. So as I mentioned earlier, Canada prohibits the export of U.S. origin items to U.S. sanctioned countries, including Iran, Syria, Cuba, and North Korea, without getting a permit. In this case, the allegation is that these businessmen were trying to obtain U.S. origin parts for the rail systems in Iran, and they did so, and I believe at least attempted to ship those items to Iran. And they've been charged, and they are now going through the prosecution process. This is important because I think it shows the link between our 2 export control systems, but also because I think the Canadian government wants to be able to demonstrate to the U.S. government that we are, paying attention to national security issues up here, particularly when it involves U.S. goods and technology, and that we're tracking these items when we're here, and that we will not be, simply a vessel for avoiding or undermining U.S. law when it comes to export control issues.
John, if I could ask you now to maybe take some look into the veiled land of the future, although since it's 2016, it might be a little bit later in 2016, but perhaps 2016 and beyond. Obviously, in the United States and in Houston is a huge deal around Iran. Cuba also, because a lot of actually Cuban Americans came to South Texas, even though the majority went to South Florida. But we have a large Cuban American community here, and of course the native tie or the native language tie with Spanish is something. We've had our very conservative Texas governor already go to Cuba to perhaps foster trade ties. So what developments for 2016 might you foresee around Cuba, and maybe end up with what do you think both Canadian and or U.S. companies need to do in terms of their export control policies around some of the things you've seen and some of the places you see things going in 2016?
Yeah, let me first, Tom, cover Iran, because this is the one that's in the headlines now, and I think is of interest to companies on both sides of the border. Canada traditionally has been very aggressive when it comes to relations with Iran. We've pulled our embassy out back in 2012. Our previous government, I should say, has made it very clear that they did not feel Iran was acting truthfully and honestly in the negotiations for the JCPOA, or abiding by their UN obligations, that they were building a nuclear weapon. Our government has always been very aggressive on that point. That was the previous conservative government, and it's important to note that in the past 8 years or so, our government has become, I think even some of the U.S. commentators have used this language, a sanctions hawk when it comes to Iran, Burma, Syria, and North Korea, and a number of other countries. And that's very different than the approach before then by earlier governments. We've seen the government increase increase the breadth of its sanctions measures, put in place in some, as I mentioned earlier, in some cases more measures that are more aggressive than the U.S. or the EU. Unfortunately, they haven't backed it up with resources, and what I mean by that is, if you're a Canadian company trying to find some guidance on how economic sanctions are applied, it is very difficult to get that guidance. There is no government department that has been set up to provide guidance. We have a government department made up of 4 or 5 lawyers that manage the permit process under our economic sanctions legislation. However, they will readily tell you that they're not there to assist exporters or assist Canadian companies. They're there merely to administer the permit system. And that's an important background to, I think, understand what's happening now, because since October we have a new government, a Liberal government now, that has been sending some very positive signals with respect to Iran. They plan to put the embassy back, reestablish the embassy in Iran. That was made clear in one of their election promises. And now we believe they're in the process of deciding to possibly relax the sanctions against Iran. So, in some respects, the U.S., I think, has been very clear, although, you do maintain broad sanctions for U.S. persons and entities. Some of the secondary sanctions have been repealed in response to the JCPOA and Implementation Day a couple of weeks ago. The EU has significantly repealed sanctions, so has Australia and Japan. Our government here in Canada, the Liberal government, still relatively new, is trying to figure out how to respond to this. For the time being, our very aggressive sanctions on Iran still are in place. So Canadian companies are a bit worried about that, particularly in the oil and gas sector. As you know, in Houston, it's a very difficult times for that sector right now. That's one area where there are a number of Canadian companies that feel they could assist in the energy sector in Iran with technology, with equipment, with services, and they still haven't been given the signal yet from our government here that there will be repeal of sanctions. Aerospace is another area where Iran is very interested in, and of course in Canada we have Bombardier and a number of other aerospace companies and aerospace technology and expertise that could be of great assistance to Iran. Right now, our countries, at least Canada, is going through an economic slowdown. So there's a lot of pressure on the government, I think, to relax these Iran sanctions. I would be surprised if they didn't, and I would think we'll see a decision to that effect within the next few weeks, if not the next few days. And Canadian companies will re-engage in Iran in competition with European, Japanese, and Australian companies as well. So Iran is a really exciting area right now for Canadian companies. We're just waiting for that signal from our government that there'll be a repeal of sanctions. While that occurs, while that repeal may occur here in Canada, those measures I mentioned earlier that restrict U.S. origin and technology from moving from Canada to Iran, I think will remain in place. We'll continue to respect the U.S. trade embargo. So if the U.S. still, applies re-export controls on its U.S. origin goods and technology, I think Canada will respect that. So Canadian companies will need to be very careful not to move U.S. origin goods or technology from Canada to Iran once sanctions are relaxed. And we'll also have to be very careful around U.S. citizens who continue to be subject to the U.S. sanctions on Iran. A number of U.S. citizens are working for Canadian companies, so that'll be an issue that'll have to be watched as well. In the area in Cuba, Tom, that's a very interesting one because as you may know, Canada has been engaged in Cuba for a very long time.
Right.
While the U.S. has, over the years, I guess since 1963, been pulling back, Canadian companies have been moving in. Sherritt and others are very active in Cuba. We are one of, if not the biggest, one of Cuba's largest trading partners, its largest source of foreign investment. So a lot of Canadian companies are down there already. The challenge right now, and it's been a challenge for a while, is we have a blocking order in place in Canada here, and it prohibits Canadian companies and their executives and employees and directors from complying with the U.S. trade embargo of Cuba.
Very familiar with it.
Yeah.
Yes.
And it's shocking when you explain this to someone in the business world that this could be the case. They're stunned that two close trading partners, and very, very close economies, very close relationships, would have where Canada would have a law that would make it illegal to comply with the other country's law. But we do, and so this is particularly a challenge for Canadian companies that are owned or controlled from the United States, and there's still U.S. Restrictions on those Canadian entities that are owned or controlled from the United States. And as far as the Canadian government is concerned, as far as Canada is concerned, under our law, those American-owned or controlled entities here in Canada must comply or must not comply with the U.S. trade embargo. They're required to comply with Canadian law. Does that mean you have to trade with Cuba? No, it doesn't. But if you have Cuban trade opportunities, if you're approached by someone for providing goods or services or technology or software to Cuba, and you refuse, and one of the reasons for that refusal is the U.S. trade embargo of Cuba, you're subject to criminal prosecution up here in Canada. So it's a crazy kind of conflict situation, but it exists. And one of the challenges now with Cuba opening up and potential relaxation of the U.S. trade embargo of Cuba is that Canadian business people, companies are reading the headlines and they're thinking, oh, the U.S. has pulled back its trade restrictions, and in large part the U.S. hasn't. It's my understanding, and you can probably confirm this, Tom, that that's largely the responsibility of the U.S. Congress. And the U.S. trade embargo of Cuba largely remains in place. And unfortunately, when companies are going down the road of exploring these opportunities and then all of a sudden find out, oh no, we can't because of the U.S. trade embargo of Cuba, they're now exposing themselves in Canada to a potential violation of the blocking order. So
Right.
A lot of our work in the last few months since these signals have been coming out in terms of the U.S. trade embargo of Cuba, a lot of our work has been explaining to companies that they need to tread very carefully here, and that, again, we still have a blocking order in place. The U.S. trade embargo is still largely in place. Another aspect of that is as soon as a Canadian company gets a communication from its parent in the United States, for example, about the Cuban trade embargo, that's kind of an intimation of policy or an instruction not to do business with Cuba, that has to be immediately notified to our Attorney General here. So there's lots of these little quirks in that kind of trading relationship with Cuba, which is still providing challenges for Canadian companies, even as the U.S. is going down this road of liberalizing trade with Cuba.
Well, John, unfortunately, we're to the end of our time, but I was wondering if anyone wanted to follow up with you on any of the points you've raised. Is there a way they could email you, and if so, how would they do it?
Yeah, absolutely. They can reach me at Boscariol, that's Boscariol, at McCarthy, McCarthy.ca.
John, I really appreciate this. Like I said, it's been long overdue. I'm a huge fan, and I look forward to continuing the conversation. So thank you very much.
Oh, thank you very much for this opportunity, Tom. Next one we should do should be anti-corruption law in Canada. We'll have more to report on that, too.
Well, when you're ready, let me know.
Yeah, absolutely.
Okay, thanks.
Thank you, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. If If you have any questions on this episode, I would ask you to shoot me an email at tfox@tfoxlaw.com. Also, I'm developing questions for our next mailbag episode. So if you have any questions you'd like answered or at least explored on the podcast, you can email me with any of the questions you have. I hope you enjoyed this episode and greatly look forward to visiting with you again. Thank you again.